So today we're going to talk about tenant screening, guys. This is a very informal presentation. So feel free to jump in, ask questions as we go along. If you ask a question that's going to be covered in a slide that's just a couple away, I'll say that. But it's basically an open forum and a discussion. So feel free to ask questions. And hopefully by the end you'll have found that this was a useful presentation for you. So I will say right up front, okay, our success as landlords and investors is directly related to our ability to find quality tenants. I know people who have gotten into situations where tenants have stopped paying and they have lost their properties. Okay. I had situations where I had tenants where they stopped paying because the government said they could stop paying and not be evicted. And it took me 18 months to get them out. So screening your tenants is critical. It's the first step in risk mitigation for a landlord. And we have to realize that we only control the property, especially in Ontario, until the tenant moves in. Once the tenant moves in, they have a lot more control of the property than we do. And our ability to get them out for not paying or other infractions is limited. And we have to follow Residential Tenancy Act guidelines and rules and go through hearings and all kinds of things. We are in much better shape if we can stop a bad tenant from getting into our property than trying to get them out afterwards. So the process is actually fairly straightforward, okay? The tenant applies to rent an apartment based on an ad that they see. The tenant completes a rental application. Now, in many jurisdictions, you are allowed to charge an application fee. I like a $50 refundable application fee. If the tenant doesn't show up for the appointment, they forfeit the $50. If the tenant shows up and is not selected, the $50 is returned to them. And if the tenant shows up and is selected, the $50 is put towards their final rent deposit, security deposit, last month's rent, etc., whatever applies in the jurisdiction you're in. Not all jurisdictions will allow a deposit with the application. So you have to be sure and verify the residential tenancy rules where you're renting. Now, in Ontario, we are not allowed to collect an application fee, but we are allowed to collect last month's rent. And we are allowed to collect last month's rent as part of a rent deposit, as long as that rent deposit is paid before the lease is signed. So it is perfectly legal, as long as you word the deposit correctly, that the $50 is part of the rent deposit. And if the tenant is selected, they will owe the balance of the last month's rent. And if they're not selected, then they will be refunded. So there are ways that you have to word things depending on the jurisdiction in order for it to comply with the requirements for deposits. The key is, if there's no deposit of any kind with the application, then I can tell you, you will have 10 appointments for the day and 7 of them won't show up. And meanwhile, you've spent your whole day scheduling people and trying to arrange for your property to get rented, and the tenants just don't show up and they don't notify you because they have nothing on the line. So I only show a unit to a tenant who, number one, has completed a rental application. Never show a unit to a tenant who hasn't at least completed a rental application. And secondly, wherever possible, I like to get a small amount of money as a commitment that they're actually going to show up. So the rental application is actually pretty standard across most jurisdictions. So you are going to have tenants who complain about information that's on the rental application. But if you Google rental applications, you will find that this information is standard across most jurisdictions, and is not out of the ordinary. So it should contain the full names and contact info of all adults who will be living in the property. It should have the driver's license information of all adults on the application. It should have the full names of other residents and the relationship to the prospective tenants. Okay. You are looking to find out how many people are intended to be living in the property. You want the previous 2 addresses with length of tenancy and landlord contact information for all of the people who are going to be your tenants. And you want employment and income information as well. So you want to know their current employer, name and address, their income, their length of time on the job, who their supervisor is, and contact information, because you're going to be contacting their employer and making sure that they're actually working. And you want the same information for a previous employer if they've been at the current employer less than 2 years.
Excuse me, Rob?
Yep.
And Kelly has a question.
Okay, go ahead. Yeah, because if I'm looking at the presentation, I'm not seeing hands up. So if somebody's got a question, go make sure that you got it. Go ahead, Kelly.
Thank you. I actually just typed it in the chat as well. I wanted to just know if you had this $50 applications and then you had a couple of people come check out the house, and the ones that were not interested, how would you refund the $50 back to them?
Did they show up?
Yeah, say they showed up, but
If they
were
showed
not
up,
interested.
if they showed up, absolutely they get their $50 back. Absolutely. The $50 is designed to make sure they show up. It's
Okay.
not designed as a fee. Okay. The $50 is designed to make sure they show up.
Gotcha. Thank you.
You're not charging them to show them the property, which probably in Ontario would be illegal.
Thank you.
Okay, no problem. So the rental application will also have banking information. So the bank, the branch, the address, the account. It's going to have existing debts and monthly payments. It's going to have the make, year, model, and monthly payments for their vehicles. And it's going to have what their current pets are: type, breed, weight, age. And it's going to have personal references. Now, you're going to find that this information is pretty standard across all rental applications. If a tenant does not want to fill it in, my general rule is next. Okay. The one exception, okay, is the banking information. If a tenant says, if we agree and I'm going to become your tenant, then I'll give you my banking information, then I'm okay with that. But other than that, it's very fair game to ask for existing monthly commitments and existing monthly obligations if they're going to become your tenant. You need to be able to verify that they can actually afford to live in your place. It does no good to say a guy is making $100,000, okay, if he's got all kinds of debts and he's got a $2,000 car payment and he's got credit card debt up to his ears, okay. His income at that point is not relevant because he's not going to be able to afford the rent because he's got so many other debts. So the debts, the vehicles, the assets, the liabilities are an important part of the application as well as the references. Any questions on that? Are we good?
So far, so good. Oh, there's a question from Natalia.
Yeah, go ahead.
Yeah. Hi, Rob. What about the credit report? Do they send you a copy? Do they have to? Would you ask them? Yeah.
They are not going to submit a credit report. Okay, we are going to ask for our own credit report.
Okay.
We are going to ask for a credit report on the application, and we'll get into that in a second. Okay. Actually, we'll go with that next. Are there any other questions before we leave this? Okay. So a key part of the rental application, and that most landlords do not do, and it is a huge faux pas. Okay. Your rental application should also contain specific rules for your property. You want the tenant to know what the rules of the property are before they even see the property. Okay? So you are going to have rules in there, or what your rules are, if you have any, for smoking and drugs, for pets, for parking, for storage, for insurance, for restrictions on use of the property, laundry, yard, garage, sheds, short-term rentals, vehicle charging, etc. These are all going to be on the rental application on a back, and it's going to say, I have read and understood the rules of the property. Okay? It's also going to have responsibilities for property maintenance. Who does what? What happens in tenant absences? What inspections are going to be done? If it's a condo, it's going to have that the tenant agrees to adhere to the condo rules and regulations, and they will get a copy of these with the lease. It's going to have the landlord's rent payment preferences, and it's going to have grant permission to the landlord to do a credit and background check on the respective tenants. So the landlord is going to do their own credit check, and the landlord is going to call both the references and the previous landlords. All good? Okay, so let's dive into some more details. Smoking and drugs. Okay. Is smoking, vaping of any kind allowed in the unit, common areas, building, or on the property? If it's a multi-family building, a landlord is allowed to restrict smoking, even to the point of saying there is no smoking on the property. If it's a single-family home where the tenant has exclusive use, the landlord is allowed to restrict smoking to not being in the unit itself. They can say you're only allowed to smoke outside. The landlord is also allowed, and I get into arguments this on the tenant and landlord boards all the time, the landlord is allowed to say whether or not legal recreational drugs are allowed to be grown on the property or in the unit. And if any of you follow me on the various boards, I have tenants all the time who say they're renting the property, they can do what they want. No. If a landlord specifies in the lease and is agreed to in the lease with the tenant that the growth of recreational drugs is not allowed on the property, that is an enforceable clause. And I tell people all the time, just go Google it, just go look it up. That said, if there is nothing in the lease and the tenant grows pot in the backyard, the landlord can't do much. This is why the rental application is so important. It details the rules that are going to apply to the property, and those rules will form an addendum to the lease. And even in Ontario, you take the standard lease, and there's a spot in there that says additional clauses that apply to this lease, and you attach an addendum with all of the rules that you're going to agree to. Parking. How many parking spaces are allotted to the rental unit? Is there a specific location where parking is allowed, not allowed? Are there restrictions on what can be parked on the property? You'll see people who will park trailers, unlicensed vehicles, vehicles being maintained. What is allowed to be parked on the property? If you have a multifamily unit, are parking spots assigned? What happens when a tenant wants to park multiple vehicles? Okay, if you have a single family home and you have a driveway and a tenant's got 2 cars, it's probably not a big deal. If you have a 12-unit apartment building with 12 parking spaces, then it becomes a big deal when a tenant brings in a second vehicle. So all of these things should be detailed in your application, what your parking rules are. Pets. So in Ontario, no pet clauses are not enforceable. Even if you put them in the lease, they're not enforceable. You cannot prevent someone from acquiring a pet once they occupy the unit. But you can evict someone for lying on their application if you have everything written up properly. Okay? So you are allowed to not pick a tenant because they have pets. If they get a pet after they move in, you can't do anything about it. But if they have a pet, declare they don't have a pet, and move in with their pet, that's lying on their application. And I'll talk about lying on your application a little later. The other thing to note is that pet restrictions are covered by municipal bylaws, okay? And if a landlord will explicitly allow pets, there should be a clause in the lease and in the application that says that the tenant agrees to abide by local municipal bylaws and animal control bylaws. That is important because I know situations where tenants have brought in 6, 7, 8, 10 dogs. And there's no clause in the lease, and all of a sudden you've got animal bylaw at your door, and you've got the next door neighbor complaining about the barking, and you've got a problem because there was no clause in there that said there are municipal animal control bylaws. So very important that you include that as well. Storage. Does the tenant have access to storage in addition to their unit? In the basement, in the garage, a shed, etc. If not, specifically say so. I know landlords who've gotten into all kinds of trouble because they have a shed in the backyard where they keep their lawnmower and stuff and stuff to do yard maintenance. And all of a sudden the tenant wants use and the landlord lets them store the stuff in there, doesn't say anything. It's never been declared as part of the lease. And all of a sudden it becomes an assumed amenity. Assumed amenities in Ontario are a bad thing for landlords. If a tenant does something and the landlord doesn't correct it, or there's nothing in the agreement to say what they are allowed to do or aren't allowed to do, after a year, it becomes an assumed amenity and you can't take it away. Insurance. This one boggles my mind. Tenant insurance is not mandatory in Ontario or any other province in Canada for that matter, but you can require it as part of your lease agreement. If you do not say that the tenant must have insurance in your agreement, the tenant doesn't have to get insurance. Okay? So in your application, it should say something along the lines of the tenant will be required to purchase a tenant insurance package to protect their belongings and insure against liability. And there are all kinds of clauses you can put in to make sure that what you're asking for is legal. You can specify the minimum amount of liability. You can also specify that the tenant understands that their insurance covers their belongings and that the landlord's insurance does not cover their belongings and the landlord is not responsible for their belongings. So very important, if you expect the tenant to have insurance, it should say so on the application and it will be a clause in the lease. All of these rules that we're talking about, they will become clauses in the lease. What proof of insurance must the tenant provide and how often? So I've always required my tenants to provide me with proof of insurance before they get the keys. And I ask for annual proof of insurance on renewal to show that they've renewed it. Now, I know other people and I was not aware of this until recently, a landlord can actually ask to be named on the tenant's insurance policy as an interested party, so that if the tenant changes or cancels their insurance, the landlord would be notified. So it was only about a year ago that I became aware that a landlord could actually request that and have it done. But a landlord can request as part of the insurance and say that the tenant agrees to put the landlord on the insurance policy as an insured party, and so that the landlord will be notified of all changes to the insurance. And a landlord is allowed to refuse to lease to a tenant who does not agree to obtaining insurance. And a landlord is allowed to evict a tenant who cancels their insurance if it's in the lease that they will have insurance. Again, this is why we're setting this up. It's very important that the rules be clearly defined before the tenant signs the lease and that any of the rules be reflected in the lease. Restrictions on the use of the property. Does the tenant have access to services like a laundry room? Does the tenant have access to use of backyard, deck, patio, shed? All of these things need to be clearly defined, because if a tenant rents a property and starts using the backyard in a multifamily situation, and they use the backyard and there's nothing in the lease that says they can't, or there's nothing in the lease that says they have their own space within the yard, and they use it, the landlord is not going to be in a position where they can go and take it away later. So very important. If electricity is included in the rent, is the tenant allowed to charge a vehicle? I personally don't allow vehicle charging on my properties if I'm paying for the rent. And that was a big deal in my building in Windsor as people started getting these electric vehicles and electricity was included in their rent. So very important that electricity usage, if it's included in the rent, be very carefully explained. Okay. What is the tenant allowed or not allowed to add to the property? Okay. Can a tenant add a pool, a trampoline, a storage shed, a vehicle charging station? What can they do? If you do not specify, you could find yourself in problems. And does the landlord retain use or access to the property? A garage, a shed, parking, etc. These are all things that need to be explicitly explained, because otherwise, if the landlord needs to do something on the property, they may not be able to access it anymore, or they may need permission to even go on the property. Short-term rentals. In some jurisdictions, including Ontario, a landlord cannot prevent a tenant from taking on a roommate, paying or not, nor can they prevent a tenant from subletting the unit. So understand, okay, you can't do this. That said, short-term rentals is considered a change of use for the property. It's considered a commercial use of the property, and the landlord is allowed to restrict it. The landlord is allowed to restrict it and needs to, because there are laws in various municipalities that prevent STRs and prevent what can or can't be done on the property in the way of short-term rentals. The landlord also needs to be aware that there are tax implications to their property being used as a short-term rental. So make sure in your application, okay, that you discuss what short-term rentals, a clause about short-term rentals, and that will also appear in the lease. Responsibility for maintenance. So in Ontario, a landlord is required to maintain all common areas in a multifamily property, including snow removal, ice removal, cutting grass, etc. That said, a landlord may designate some of these maintenance items to the tenant if they have exclusive use of a single family property. Okay, I say some of the items because some maintenance items cannot be assigned. Okay, so general repair and maintenance cannot be assigned to the tenant in the case of a single family home, but you can get them to shovel the driveway and cut the grass. The landlord's still required to change the furnace filters and repair a leaky faucet. Okay, so you have to understand the difference between what you can and get the tenant can and cannot get the tenant to do, and make sure that that's explicitly defined on your application and in your lease. If you're going to rent a single family home, then you want to make sure that the tenant knows that they're going to be shoveling the driveway and cutting the grass. Absences. Tenants have to be aware that if they're going to go on a holiday or they're going to be absent from their unit, they have to notify the landlord. Okay, the landlord may have insurance requirements. The landlord needs to know if the property is going to be vacant. And the landlord also has to say, you are responsible to have your unit checked and to have the mail picked up. Okay, these are things that are important. Other things, if the tenant's going to be away for 2 weeks, okay, does the water need to be turned off? Do they have to maintain the unit at a particular temperature? You don't want them leaving in the winter and turning the temperature off and having the pipes freeze. Okay, so if you're going to have absences, you need to make sure the tenant understands that they have to maintain the temperature at least a certain level. Okay, and that if they're going to be gone for any period of time, you want them to turn off the main water, things like that. These are all things that should be part of the rules of your property, and the tenant should know they exist. Inspections. Many tenants don't believe that the landlord has a right to inspect the property. If they're renting it, it's their property and they can do what they want. That's not correct. A landlord is allowed to do both regular and ad hoc inspections of the property to ensure that the property is being properly maintained and that the property rules are being followed, and to do routine maintenance. Okay? Routine maintenance is going to include things like checking the operation of smoke and carbon monoxide alarms, changing furnace filters, cleaning eave troughs, etc. These are things that the landlord is going to be responsible for when it comes to maintenance, and he needs access to the property. Okay? Proper notice must be given to access the property. So it's a general rule. In Ontario, for example, is 24 hours written notice, proper notice. Okay? And the intent.
Rob?
Yep.
Sorry, Kelly has a question again.
Okay, go ahead, Kelly. I think you're muted, Kelly.
Oh, I'm sorry. I think I did not put my hands down after the first time. I don't have a question this time. I'm so
Not a
sorry.
problem.
I'll put
Yeah,
it down now.
No worry at all. We're just trying to make sure everybody's covered off. Okay. And the intended frequency of inspection should be detailed so that expectations are clear. With my tenants, I always did inspections every 6 months. Okay. And it was right in their lease, and they knew upfront it was going to happen. Okay. I still schedule it. I do it when it's convenient for them, and I do it a month in advance. And I'll say we were coming up time for our inspection, for our semi-annual inspection. Just want to confirm when is a good time to come and do it with you. And you have an inspection checklist. The inspection checklist is going to be very similar to the check-in and check-out checklist. Okay, you go through and you check and make sure that the property is being looked after properly. Okay, and that there's a normal level of cleanliness, and that there's nothing weird going on, and that rules are being followed. If a tenant knows that there are going to be regular inspections, they tend to behave differently. And a tenant that doesn't want inspections could turn out to be a problem tenant. So make sure that you make that clear in your documentation, and make sure that you give proper notice. Condo rules. This one is always touchy. Okay. In many cases, condo rules and regulations do not line up with tenancy laws. In Ontario, for example, pet laws and checking the unit during absences. Okay. Condos have rules for these things. A tenant needs to understand that they have to follow the condo rules. It doesn't matter what the LTB says. It doesn't matter what the RTA says. Condo rules take precedence. And the LTB recognizes that condo rules take precedence over Residential Tenancies Act. And the LTB will allow the enforcement of condo rules. Okay? But you need to make sure the tenant is aware that the condo rules take precedent, and the tenant agrees. If they don't agree, you don't rent to them. And that there's a clause in the lease that says that the tenant agrees to abide by the condo rules, and that you provide the tenant with a copy of the condo rules when you are actually renting the condo to them. Rent payment preferences. In some jurisdictions, including Ontario, the landlord cannot enforce the way in which a tenant pays rent. If a landlord does not have an agreement with the tenant the tenant can pay rent any way they want, but a landlord can request a specific form of payment. So a landlord can say, my preference is for electronic transfer or automatic debit or post-dated check. If the tenant agrees to that, and that becomes how the tenant starts paying rent, and that is what's in the lease, then the tenant can't change it. The converse is also true. The landlord can't turn around and say, I now want electronic payments if the tenant was never required to make electronic payments. Okay. You can establish what the payment preference will be prior to the tenancy, have it as part of the lease, and that does become a legal obligation on both parties at that
Rob,
point. Yep.
question from you.
Yeah, go ahead.
A question, Rob. So if the building is sold while this rental agreement is in place, I think I heard a horror story when the tenants refused to pay to the new landlord. Does it mean to make sure that the new landlord receives the payment, do they need to re-sign the rental agreement with a tenant, or how can
No.
we?
No, there will be a direction. The lawyer's office will issue a direction to the tenants that says that the building has been sold and that from this point forward, rent payments are to go to the new landlord. Now, the new landlord cannot unilaterally change the payment of method. If the tenant has been paying by check on a monthly basis, the new landlord can't now require electronic transfer of existing tenants. He cannot change the lease terms. He is accepting the leases as they are. But there will be a direction for the for the tenants to pay the new landlord now instead of the old landlord.
Okay, got you. Thank you.
Okay. So this is part of what most tenants do not realize. The rental application is a legal document, and it is against the law to lie on a tenant application. It is considered fraud. And anytime tenants talk about lying on the application in order to get a unit, okay, I say Google it. It is fraud. Tenants can be evicted for illegal activity related to their tenancy, and fraud is an illegal activity. Okay, there is a reference to a paralegal company that talks about it, and it's clear. There are many misunderstandings and common false beliefs among both landlords and tenants regarding the criminality and other unlawfulness involved intentionally making false statements. Criminality and tortiousness may occur when false information is used to induce or coerce others to enter into contractual relations, including tenancy agreements. Okay? This is key. And on your rental application, just above the signature line, there should be something that says that the tenant warrants that all of the information provided on this application is, to the best of their knowledge, true. The tenant understands that it is a criminal offense to deliberately make a false statement on a rental application, and that the tenant may be evicted if such false information leads to their tenancy, something along those lines. These things are key in order to protect a landlord, because tenants lie. They lie on their rental applications in order to get the unit. And if you then give them the unit, getting them out is a difficult proposition. So, documentation. Oh, before we leave that, let's just go back. Any questions on the rules for your property? What needs to be in the rental application? How and how it translates into the lease? Any questions on that?
Just chime in, Natalia. You're muted.
Oh, sorry. so if so that applies if I manage the property myself. What if there is a property manager and the property management company, I would say, that have many tenants? Would they take my agreement, my rental agreement, and manage that in accordance with the conditions in this rental agreement, or they would have their own rental agreement that they will kind of impose on me that
Well-
will be signed? And the second question, before I forget, Rob,
Yep.
if, for example, is it possible, for example, to delegate the maintenance duties to one of the tenants and credit him against the rent, like for the services?
Oh, okay. So the first one, okay, you make an agreement with your property manager. I know that most property managers have their own rental application. If you have things that are important to you, you negotiate with the property manager to have an addendum to the rental application. I know that in Phoenix, I've done that several times where we've run into issues with the condo board or something else. And so we've added things to the rental application, specifically that talk about tenant agrees to condo rules, tenant pet restrictions, because the condo board has pet restrictions. We actually added on there the point that a tenant understands right underneath in our section, okay, right underneath our pet section, okay. Our pet section is very clear. It says breed, weight, and type of animal, and there's a tick box there that says I do not have a pet. Okay, if somebody does not answer the pet question, they're immediately thrown out. The application is thrown out. If they say they do not have a pet, then it says underneath, okay, understand that tenants may be evicted for lying on an application. And especially in the US, okay, pets are a big issue because homeowners associations have restrictions on the types of animals that people can have. And it's not just condos, it's homeowners associations. And tenants have to agree to abide by whatever the rules are, not only within the municipality, but within the homeowners association. Second part of the question was what?
The second part was if I delegate, for example, some maintenance work to one of the tenants and credit him for this work done against his rent. Is it
okay? Now that has to be done in Ontario. That has to be done as a separate agreement. I know in Alberta, you can it's much freer how you do it. Okay, it depends on the jurisdiction. In Ontario, if a tenant is going to be hired, quote unquote hired, to do specific things like shoveling the driveway, like cutting the grass, okay, then that has to be a separate agreement and they have to be compensated for it. That is separate from their rent. How you choose to document it as a payment, okay, you could turn around and document it as a ledger payment so that you provide them a receipt every month with their full rent, less payment for services. So net payment amount is, okay, you're allowed to do that, but you have to make sure that there is a distinction, specific distinction for the amount that they're getting for this, for what they're being paid. It can't be quote unquote built into their rent. In Alberta, you can. In Ontario, you can't.
Gotcha. Perfect.
So
Thank
again,
you.
make sure to verify the rules in the jurisdiction you're in.
Rob,
Yep.
this rings a bell in Ontario, but you could probably confirm it quite easily. If you are taking on a tenant to be a custodian, for example, don't you have to declare that to, I don't know the governing board in Ontario. Here it's the CNESST.
You don't necessarily have to declare it in Ontario. You can take on, basically you're talking about a situation where you got a superintendent and part of the remuneration is their unit. Right?
Yeah.
Yeah. So you're allowed to do that, and that doesn't have to be declared. That would just be part of your, essentially, they're not a tenant to you. Okay.
I know. What if they have an accident?
What do you
You remember when sorry, I'm going to go off on a tangent for an example that Rob will understand. When we were with Rich Dad, anybody who was in Ontario had to get permission from the, get a letter from the construction association or something like that
for
insurance purposes.
Well, you would need, if you are hiring somebody to be your caretaker, there are different conditions. Are they your employee or are they a subcontractor? Are they managed as an independent employee, or are they your employee? Because if they're your employee, then you have payroll implications, you've got withholding tax implications, so you've got different considerations.
When we were subcontracted, you and I, Rich Dad was obligating us to get a letter saying or get insurance through Ontario.
Yeah, well, we had what we had to get was liability and omissions insurance, and
there was also another one. I didn't have to get it because I was in Quebec.
Okay, I only had to get liability and omissions insurance. That was it. And are you talking about workman's compensation? Because workman's compensation is another issue. Workman's compensation would be if you took on the superintendent as an employee, then there would be WCB that you would owe.
Okay.
Again, it depends how you structure it. And if you're going to get into a situation like that, like it's common if you had, let's say, a 30 or 40 or 50 unit apartment building to have an on-site superintendent. If you got a 12 unit building, you probably don't. And your property manager is probably not on site. So it will depend on what you're doing. And again, if you're getting into something that size, I would be talking to your lawyer about how to structure it. Good. Okay, so documentation. Tenants will argue with you about what they have to provide, but a landlord can ask for virtually anything they need to verify a tenant's identity and their ability to pay rent. Okay? A landlord can ask for these things. If you go to a bank and you want a mortgage, they ask for 2 pieces of photo ID to verify that you are who you are. If you open a bank account or an investment account, they ask for 2 pieces of ID. Okay? If you travel, the airline asks for piece of photo ID. Okay? You are allowed to ask for that. And you are allowed to ask for any documentation you need to show that the tenant can pay the rent. This includes government photo ID with addresses, proof of employment, letters from employers, recent pay stubs, tax returns, notice of assessment, bank statements. Okay? You are allowed to ask for these things in order to verify that the tenant can pay the rent. A tenant who makes $100,000 and has a brand new truck, the $100,000 truck, is making $2,000 a month payments on their truck. This is why you want to know. You want to be able to verify that the tenant, in fact, does not have large liabilities. That's one of the reasons, one of the things you're going to be looking for on the credit report. The credit report is going to tell you what the tenant has outstanding. It's going to show liabilities on credit cards. It's going to show outstanding debts that are related to their credit. So if you want a good article on what a landlord can ask for in a rental application, you can find it at that link. Okay? Tenants know their rights. It's important that a landlord not overstep what they're allowed to do. And this is why when I talk, I always say, verify your jurisdiction. There are things that apply in Ontario that don't apply in Alberta, that don't apply in Texas or Arizona. Okay? Make sure you understand what the rules are in your jurisdiction and how you can apply them, because tenants have free legal counsel in most cases. They can go in and they can get free help, okay? And if a landlord is overstepping what they're allowed to do, okay, they can be in trouble.
Rob, is it possible to put the link in the chat so we can use it as a link?
Let's go back. Can I copy that? I can copy that. Just a second. Let's go to presentation. I can't do it there. Let's go back. Let's go here. My presentation and see where I can grab that. There we go. Now my presentation might get all screwed up, but we'll figure it out. Now I got to go back here into the chat, paste that.
Thank you.
No problem. Now let's just hope my presentation isn't all screwed up and I got to refigure out where I am. But we'll figure that out. No problem. Okay. Good. Okay. Examine all documents very, very carefully. It is easy to edit a PDF. I do it all the time. Okay. When I get my bank statements or I get my statements from my property managers, they send me a PDF. I go in and I edit my PDF and I add my comments. Okay. But you can edit anything on a PDF. So be careful. Make sure you call employers to confirm status. Make sure you call previous landlords and not just the current one. The current landlord may be trying to get rid of the tenant. The current landlord may give you a glowing reference because they want them out. Okay? Make sure you talk to more than one landlord if the tenant has not been in their current place more than 2 years. And call personal references. Always do an independent credit check. Do not rely on a credit check provided by the tenant. You can ask the tenant that they provide a credit report, but let them know that you will still be doing an independent credit report. Okay. But that if they want to provide one of their own, because they may be going to several different landlords and not want every landlord doing a credit check, let them know that before they are accepted as a tenant, you will be doing your own independent one. It's the same thing if you're applying for a mortgage and you're at multiple banks. You tell them, okay, do not pull my credit. Here's a copy of my report. If I end up getting my mortgage from you, I understand you'll be doing your own. But until I say go, don't do it. Okay? Review the credit report carefully. Look for past payment history. Past payment history is a really good indication of future behavior. But also be aware that if there's a glitch on the credit report, find out about the story. Okay? There are going to be people who have problems with their credit report. You need to understand whether this is a temporary glitch as a result of a life event or whether this is a pattern of debt collection and not paying bills. Okay? Bad things happen to good people all the time. Divorce, illness in the family, death in the family, job loss. Okay? Is this a blip in their credit or is this a pattern? And that's what you've got to determine. Due diligence. Make sure you do your due diligence before they become a tenant, because once they're in your property, it may be difficult, time-consuming, and expensive to get them out. Like I said, it has taken me as long as 18 months to get some tenants out of a property in Ontario. Okay? It is a long, arduous process. The tenant stalls at every step. They're not ready for hearings, request delays. You get an eviction notice, they still don't leave. You need to get a sheriff. Okay? It's not an easy task. And if an agency or agent has sent you a tenant, okay, they're going to help you get the required documents, but they're not doing the due diligence. Okay? The agency may get you a credit report and may get a credit application for you, but they are not verifying that the tenant is qualified. That is ultimately up to you to accept, not the agency. I want to highlight here discrimination. It's very, very, very important. A landlord must adhere to the Human Rights Code when selecting a tenant. This is a critical part of being a landlord. Every person has a right to equal treatment with respect to the occupancy of accommodation without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, age, marital status, family status, disability, or the receipt of public assistance. You cannot turn down somebody because they have kids. You cannot turn down somebody because they're pregnant. You cannot turn down somebody because they are receiving a welfare or ODSP or Ontario Works. Okay. The source of their income cannot be a determining factor in your choice. Very important. Okay. This is why the ultimate decision of who you accept is yours. You never, ever, ever give a tenant a reason why they were not selected. Because you saw that list of reasons why you can't refuse them. Well, all there has to be is an insinuation that it falls into one of those categories, and you're in a boatload of trouble. Okay? If a tenant asks why they weren't picked, your answer is simply, I'm sorry, you were not the successful candidate, or I'm sorry, but we only notify successful applicants. That's it. Okay? Because if there is any thought that they were turned down for one of those human rights reasons, you're in a boatload of trouble. And that list is long. It took me a minute to read it. So be careful and understand what you're doing. Now, there are all kinds of great landlord tools out there. So I'll just go through a few of them. Okay. We've got the Landlord Tenant Bureau. And by the way, if anybody here, okay, it wants a copy of the presentation with all the links, I know who's on the call today, and we're going to get a nice picture of everybody. If anybody here wants one, send me an email. And I'll send you a copy of this so that you've got the links. Okay. So we got the Landlord Credit Bureau. Okay. And they handle rent reporting and tenant screening. We got Single Key. Single Key is awesome. You can get credit reports from them. Yes, they charge. If $25 a reasonable amount to charge, well, if you don't pay the $25 and you get a bad tenant and get stuck with them for 12 months of not paying rent, I think $25 is pretty cheap.
It's 30 now.
Yeah. Okay. Landlord
Yeah,
Easy.
I have a question.
Yep.
If I can ask,
Yep,
how
not
do
a
you
problem.
find about this? How do you find about single key rent guarantee program, where they screen, they can provide you the report, and then they say, do you want to sign up for the rent guarantee program?
Google it, talk to them. They've got people you can talk to. So get in touch with them and see if it meets what you want. I have never used their rent guarantee program. I don't know whether or not it is valuable.
Okay.
I know that on my insurance, I have a rental clause for loss of rent as a result of a disaster of some kind. But I've never used any kind of rental guarantee where where somebody guarantees the rent if the tenant stops paying.
Okay. Thank you.
Okay. So there's Landlord Easy that helps with tenant screening. If you sign up with Landlord Easy, there's an application, and the tenant processes their application through Landlord Easy. Okay. Canly is very useful. You can search Canly for legal decisions. So if a tenant has been evicted, you can find that they were evicted, and you can find from what the judgment was. Same thing with Open Room. Open Room will allow you to search for tenant evictions. And that's it. Anybody have any questions?
Is it for all
Sorry,
provinces?
Is what?
Sorry.
go ahead.
Is it for all provinces, the tenant evictions, the information on tenant evictions? Any province in Canada?
Different provinces will have different tools. So go wherever you're going to do business, go and search that province and talk to the people there and find out how they're doing which landlord tools they're using.
Okay, thank you.
I have a question. The website or that you mentioned for the tenant evictions, how, because some evictions, they take time before they are, I guess, posted for the public. So how accurate are those websites when it comes to
Well,
tenant evictions?
They're accurate in that the information that's there is accurate. I cannot guarantee how quickly a decision will be posted, but anything that's on there is accurate.
Do you advise going for like or foolproofing whatever is posted on there?
I advise doing whatever you think you need to do in order to validate your tenant. If you go on and you're using Canly and you find that a tenant has been evicted, if you find a name match, I would do everything to validate that the person in that judgment was your tenant or potential tenant. I would be checking with the previous landlord that they gave. I would go to a tenant and I would say, a prospective tenant, and I'd say, look, it says here that somebody with your name was evicted. Can you give me who your landlord's name was at the time of this where you were living at this time, so that I can call the landlord and confirm this wasn't you?
Okay.
Because lots of
I'm-
people have the same name, so it's possible for John Smith to have been evicted and not be your John Smith. But it's
Exactly.
also okay for you to go to John Smith and say, look, John, I'm not saying it's you, but there is a John Smith who was evicted. Can you confirm where you were living at this time and who your landlord was, so I can give them a call and confirm it's not you? There's nothing wrong with